So welcome to today's deep dive. We're really jumping into something fascinating today. Usually, when we talk about a business transaction, there's this expectation of mathematical precision.
Well, absolutely. Everything is supposed to be perfectly calculated.
Right. You sign a contract, the deliverables are listed in this stark black and white, the timelines are set, and the lawyers, they just point to clause 4B and say, well, there it is.
Yeah, they like to think that is the entirety of the relationship.
Exactly. Deliverable met or deliverable not met. It's clean. We really like our commercial interactions to be visible, to be categorized.
We want them to be entirely predictable.
Predictable, yes. But then you step out of the boardroom. You step away from the drafting table where those contracts are made, and you step into the actual messy, lived reality of human commerce.
And suddenly that spreadsheet is totally useless.
Completely useless. We find ourselves looking at a legal landscape that is murky, it's undefined, and it's incredibly volatile.
Because the moment you leave the four corners of a contract, you enter a space where businesses interact without any pre-agreed rules of engagement.
None at all.
Right. It operates entirely on implied societal obligations. I always say if we view the contract as the domesticated part of commerce, everything outside of it is the Wild West.
Wild West. And we are jumping straight into that Wild West today. We are looking at a highly concentrated, incredibly foundational piece of source material for you today.
It is extremely concentrated.
Yeah, I'll put exactly what is on the table right out in the open for you. We are working with a singular, distilled fragment of text. It's literally 6 words total.
Just 6.
The title, and then a tiny excerpt that just reads, Commonwealth Business Tort Law Analysis. Tort in Business Commonwealth. That is it. That's the whole thing.
But the brevity of that text is really deceiving.
It sounds so simple.
It does, but those 6 words establish a complete architectural framework for how the free market actually survives itself.
Survives itself. I like that.
Yeah, because we have to consider how an economy functions if businesses are only bound by the specific contracts they choose to sign.
Right, like if that was the only rule.
Exactly. And the answer is it wouldn't function at all. It would completely collapse into predatory chaos.
Predatory chaos. So our mission today, we aren't going to get bogged down in endless pages of legalese or, make you memorize a legal dictionary.
No, nobody wants that.
We are going to unpack the massive conceptual gravity of these specific words when they are smashed together. Because for you listening, whether you are an entrepreneur trying to get a startup off the ground, or a student of law, or simply someone trying to understand the invisible forces that shape literally every commercial interaction you have.
Which is all of us, really.
Right, all of us. This stuff is the hidden operating system of our economy. So let's start with the title of the source itself, right? Commonwealth Business Tort Law Analysis.
Let's break it down.
Yeah, I want to focus on that word analysis first, and what that implies about the subject matter. Because an analysis isn't just a list of rules.
No, definitely not. A rule book just tells you the speed limit.
Okay, the speed limit.
Right. But an analysis requires examining the friction between the vehicles on the road, the historical reasons why the speed limit was set there in the first place.
Oh, and the gaps where no speed limit exists but driving fast still causes harm.
Exactly. When a text promises an analysis of law, it signals that the law itself requires interpretation. It's not just black and white.
It indicates a living ecosystem of rules, I guess, rather than a static decree.
Right. We are forced to look at the mechanics of non-contractual wrongs, the torts, and how they are specifically applied to the complexities of modern commerce.
Okay, let's unpack this with an analogy for you. If general business law, like the contracts, the incorporation documents, the tax codes, if that is the rules of the game that you agree to when you step on the court.
The agreed upon rules, yeah.
Right. Then a tort law analysis is like studying the unexpected fouls.
The fouls, yes.
It's the injuries or the wrongs that happen off the ball, or there wasn't necessarily a contract in place, but someone still got hurt.
Right.
And, well, someone has to be held responsible.
That's a great way to look at it, because the word tort actually comes from Old French, literally meaning injury or wrong.
Injury or wrong.
Okay. It is the body of law built on a single fundamental premise. And that premise is that you and I owe each other a basic duty of care just by existing in the same society.
Even if we've never met.
Exactly, regardless of whether we've ever spoken or signed a document.
So applying that duty of care to a business environment, that must change the scale of the analysis entirely.
Oh, completely, because a private individual acting recklessly, they might damage a neighbor's fence.
Right, minor damage.
but a multinational corporation acting recklessly. They can destroy a local economy, bankrupt competitors, or permanently alter an entire industry landscape.
That's a massive difference in scale. Let's pull on that thread of corporate negligence a bit. A comprehensive analysis of this type, it really has to evaluate risk on a huge scale.
It absolutely does.
It's about understanding corporate liability. You aren't just looking at what a business promised to do in a piece of paper. You're looking at what a business is actually capable of doing to a third party.
Right. And it requires evaluating the concept of corporate personhood, which is tricky.
Because a corporation isn't a real person.
Exactly. You are trying to assign a state of mind to an artificial entity. If a business is legally treated as a person capable of committing a wrong, how do we measure the negligence of a decentralized corporate board?
That's a huge question. How do you prove a board of directors was negligent?
It's very difficult. An analysis has to weigh the economic benefits of allowing businesses to compete aggressively, which, is the engine of capitalism, against the societal need to protect consumers and competitors from foul play.
Which brings us to the core action of our source text. The phrase, tort in business.
Right, why the in-business part matters.
Yeah, why not just analyze torts generally? I want to push back on this a bit, because this is where I think a lot of people, myself included, get tripped up.
Okay, let's hear it.
Well, businesses mostly operate on contracts, right? Everything is papered. If I'm running a business, my instinct is that I just need to worry about breach of contract.
That is the instinct for most business owners.
Right. If I hire a supplier and they don't deliver, I sue them for breach of contract. If I buy software and it breaks, the terms of service dictate what happens. So why is tort in business treated as its own distinct beast in this text? Isn't the contract the ultimate shield?
That's the misconception. Contracts only govern the expected relationships between parties who have explicitly chosen to interact with one another.
The people who actually sign the paper.
Right. They are private universes of law. You and another party agree to terms, and you create a closed loop of obligations.
A closed loop. I like that.
But no business exists in a closed loop. Tort in business addresses the broader ecosystem, the interactions with parties totally outside your private universe.
So dealing with the collateral damage of commerce, essentially.
Precisely. Let's consider a scenario. Say your business relies on a highly specialized machine. The manufacturer of that machine owes you a contractual duty because you bought it from them.
Right. We have a purchase agreement.
But what if a completely separate company, like a massive logistics firm, negligently crashes one of their trucks into the power grid outside your factory?
Oh, wow. Okay.
And that crash knocks out your power and completely fries your specialized machine.
That would be devastating. But I have no contract with that logistics firm.
Exactly. They didn't agree to supply you with anything.
So I can't sue them for breach of contract because we never shook hands, we never signed anything. But they still caused me massive financial harm.
And this is where tort law provides the mechanism for recovery when the contract doesn't exist. It steps in to say the logistics firm owed a general duty of care to the businesses operating around its route.
They can't just drive recklessly without consequences.
Right. But business torts go far beyond physical accidents like a truck crash. The analysis gets truly complex when we look at intentional economic wrongs.
Intentional wrongs. That sounds sinister.
Let's look at how a business tort functions as the sheriff in our Wild West analogy. Walk us through a specific example of an intentional business tort.
Let's move away from physical crashes and into the boardroom.
Okay, I'm ready.
Let's take the tort of intentional interference with contractual relations, or interference with prospective economic advantage.
That's a mouthful.
It is, but it happens all the time. Suppose you run a highly successful software company, and you're about to close a massive multi-year licensing deal with a major hospital network.
Okay, big deal on the horizon.
You've negotiated for months, and they are ready to sign tomorrow. No contract exists yet, but the economic advantage is imminent. I can see the finish line. The champagne is practically chilling.
Now, a rival software company finds out about this deal, and they want the hospital network for themselves.
Of course they do.
Now, if they simply swoop in and offer a better software package for half the price, and the hospital chooses them over you, well, that is aggressive capitalism.
It hurts, but it's fair.
Exactly. That is the free market functioning correctly. You lose the deal, but no tort has been committed.
Because merely offering a better price isn't a civil wrong, it's just competition.
Right. But suppose the rival company doesn't just offer a better price. Suppose they systematically contact the key doctors at the hospital network and spread maliciously false rumors that your software has a critical flaw that will expose patient data.
Oh, that's dirty.
Or suppose they legally but maliciously poach every single one of your lead developers the day before your final presentation.
Wait, really? Just to sabotage me?
Yes, not because they actually need the developers, but specifically to cripple your ability to deliver the software to the hospital.
So they are attacking the process of the deal itself, not just competing on merit.
Exactly. They are weaponizing the open market. And here's the kicker. You cannot sue the rival for breach of contract because you don't have one with them.
Right.
And you cannot sue the hospital because they hadn't signed anything yet. Contract law is completely useless to you here.
I'm just left out in the cold.
Unless you use a business tort. This is where it steps in. The law recognizes that the rival committed a civil wrong by using improper means defamation in the first instance or predatory bad faith poaching in the second to interfere with your economic potential.
Okay, I want to break down the mechanics of how you actually prove that, because it sounds incredibly subjective.
It is very fact-heavy.
The line between aggressive capitalism and improper means seems razor thin. How does this analysis actually work in practice? We hear these terms, duty, breach, causation, damages tossed around in legal dramas all the time.
The classic 4 pillars.
Right. Let's apply them to this kind of complex, borderless corporate dispute.
Well, to understand the source text call for an analysis, we really have to look at how those 4 pillars apply in a modern context. Let's use a hypothetical scenario of trade secret misappropriation.
Oh, that's a massive area of business torts today.
Huge. Imagine Company A spends 5 years and $50 million developing a revolutionary new battery for electric vehicles.
50 million, okay, big stakes.
And Company B, a competitor, manages to get their hands on the schematics without signing any non-disclosure agreement.
No contract. So we are firmly in tort territory. Step 1 is duty. How do you establish a duty between two cutthroat competitors who owe each other absolutely nothing?
In the context of business torts, the duty isn't about being friendly, It's a duty to refrain from unfair competition and wrongful acquisition.
So there are still rules to the fight.
Right. Company B has a right to reverse engineer the battery if they buy it legally on the open market. That is fair play.
Anyone can take apart a product they bought.
Exactly. The duty of care here is the obligation not to acquire the proprietary information through espionage, bribery, or inducing a breach of confidence.
So it's about how you get the information.
Yes. If Company B hires away a disgruntled engineer from Company A and pumps them for confidential schematics, the analysis centers on whether Company B knew or should have known that the information was a protected trade right.
So the duty is essentially play the game, but don't cheat the underlying mechanics of innovation.
Precisely.
Which brings us to step 2. Breach. How do we prove they actually breached that duty?
Breach in a business tort requires looking at the specific actions taken and comparing them to a standard of commercial reasonableness.
Commercial reasonableness. That sounds like something a lawyer argues about for months.
Oh, they do. If Company B bought the battery, took it apart in their lab, and figured out how it worked, there is no breach. Like we said, they used legitimate means. But if the evidence shows Company B executives authorized payments to a shell corporation to funnel money to Company A's engineer in exchange for USB drives full of data.
That is a clear breach. That's a movie plot.
It is a clear breach of the duty to compete fairly, but finding that out, the analysis requires digging into corporate communications, financial records, and intent.
So this is where it stops being an abstract philosophy and becomes a forensic investigation.
Very much so.
You have to prove the corporation, as an entity, took an action that crossed the line. But let's say we proved the breach. Company B definitely sold the schematics.
Okay, we've got him on that.
Step 3 is causation. And this always seems like the trickiest part in a complex market.
Causation is, without a doubt, the most heavily analyzed element in any business tort claim. You have to prove 2 things: actual cause and proximate cause.
Right. Actual and proximate. Let's start with actual.
Actual cause is the but-for test. But for Company B stealing the schematics, would Company A have suffered harm?
That seems easy enough.
Yeah.
If they didn't steal it, Company A keeps their secret.
It seems easy, yeah. But in business, markets are incredibly volatile.
Right. Things happen fast.
Exactly. What if another totally unrelated company was already about to publish a patent for the exact same battery technology?
Oh, like parallel thinking.
Right. Company B might argue, Yes, we took the schematics, but Company A's secret was going to be public knowledge next week anyway, so our theft didn't actually cause their market collapse.
Oh, that is fascinating. They are basically arguing that the economic injury was inevitable regardless of their bad behavior.
Exactly. That's the actual cause hurdle.
Yeah.
Then you have proximate cause, which asks if the harm was a foreseeable result of the breach.
Foreseeable. All right.
If Company B steals the battery tech and Company A's stock price drops, that is highly foreseeable.
Direct result.
But what if the drop in Company A's stock causes a totally separate venture capital firm that heavily invested in them to go bankrupt?
Wait, really? The VC firm goes under.
Yeah, it happens.
Yeah.
So the question is, can that venture capital firm sue Company B for trade secret misappropriation?
Oh, the ripple effect. How far out does the liability go?
The analysis of proximate cause in business torts is all about drawing a boundary line around liability to prevent what courts call the floodgates of litigation.
The floodgates. Because if everyone could sue,
If every economic ripple resulted in a lawsuit, commerce would completely freeze. The court has to analyze where to practically cut off the chain of responsibility.
which perfectly sets up the final element, damages.
The money.
Right. If we establish duty, breach, and causation,
Yeah.
how on earth do you put a dollar figure on something like a stolen trade secret or a ruined reputation? It's not like totaling a car where you just look up the Kelley Blue Book value.
No, it is not. Calculating economic damages in a business tort is an incredibly complex financial analysis.
I can imagine.
You aren't just looking at the money spent on research and development, you are looking at lost future profits.
Future profits. But how do you know what they would have made?
You don't, for sure. You have to bring in forensic accountants and industry experts to model what Company A's market share would have been over the next 10 years if the secret hadn't been stolen.
That's a lot of predicting the future.
It is. You have to factor in inflation, market adoption rates, and the depreciation of technology over time.
It sounds more like an art than a science.
It definitely borders on art. Furthermore, in cases of severe intentional business torts, courts might award punitive damages.
Punitive. To punish them.
Right, not just to compensate Company A, but to actively punish Company B and deter the rest of the market from trying the exact same tactic.
So this entire four-step process really shows why the source text calls it an analysis.
You can't just plug these numbers in.
Right, you can't automate this. You can't put this into a simple spreadsheet.
Mm.
Every single step, defining the duty, proving the breach, tracing the causation, and calculating the damages, requires intense, subjective interpretation of human and corporate behavior.
And that interpretation does not happen in a vacuum.
What do you mean?
Well, the way a judge interprets what constitutes fair competition or foreseeable economic harm depends entirely on the legal tradition they operate within.
Which brings us to the final crucial word in our source text that binds this entire framework together, the word Commonwealth.
Yes, the Commonwealth modifier.
The text is, again, Commonwealth Business Tort Law Analysis. Tort in Business Commonwealth.
Yeah.
So a tort in one place, handled by one system of judges, isn't the same as a tort in another.
Not at all.
What does it mean when we tack Commonwealth onto the end? It feels like the text is specifically drawing a boundary line. It's not a global analysis. It's not just an American analysis. How does this modifier change the flavor of the business court we just spent all this time talking about?
It changes everything. By specifying Commonwealth, the source material dictates a very specific, deeply rooted legal tradition.
Okay, give us the history.
When legal scholars say Commonwealth in this context, they are referring to the family of nations that evolved from the British Empire and inherited the English common law system.
So we are talking about places like the United Kingdom.
The UK, Australia, Canada, New Zealand, India, Singapore, and many others.
So they share this legal DNA. But how does that shared DNA actually function in practice when we talk about analyzing business torts today?
To understand the Commonwealth analysis, we have to look at the mechanism of precedent, which is known as stare decisis.
Let the decision stand.
Exactly. Let's compare it to a civil law system like you might find in France or Germany.
Okay, how does that work?
In civil law, the primary source of law is a comprehensive written code. The legislature writes a massive book of rules, and the judge's job is to look at the facts of a business dispute, look at the code, and apply the specific rule. The code is supreme.
So in a civil law system, the judge is more of an administrator of the written rules.
They are essentially applying the text as written. But in the Commonwealth system, however, the law is much more organic.
Organic how?
Well, while legislatures absolutely passed statutes and regulations governing business, the vast majority of tort law was never written down in a single statute book.
It wasn't.
No, it was built case by case, century by century, by judges making individual decisions.
Okay, let's break down the actual mechanics of how a judge uses precedent, because it can seem a bit strange. How does a decision made in, say, 1890 impact a business dispute in 2026?
Imagine a structural foundation. Let's say a judge in 1932 decides a landmark case,
Okay.
like the famous Donahue v. Stevenson case in the UK. This essentially established the modern tort of negligence.
It's the snail in the ginger beer bottle case, right?
That's the one. That judge writes a detailed opinion explaining the reasoning, that a manufacturer owes a duty of care to the ultimate consumer, even without a contract.
Which was revolutionary at the time.
It was, and that decision becomes binding precedent for lower courts in that jurisdiction.
It basically becomes the rule of law.
Yes, but society changes. 50 years later, a court faces a completely new situation. Maybe it's not a physical product causing physical harm like a bad bottle of ginger beer. Maybe it's a financial advisor giving negligent advice that causes pure economic loss. The modern judge looks back at the 1932 precedent. They analyze the underlying principles.
They're looking for the DNA of the logic.
Exactly. They ask, does the logic of the physical duty of care extend to a financial duty of care? And the judge writes a new decision, extending or restricting the old rule to fit the new reality.
And then that new decision becomes the new layer of precedent.
Precisely. It layers over time.
It's kind of like a software update, you know?
Mm-hmm.
They are patching the old bugs and expanding the functionality of the operating system to handle new types of data, but the core architecture remains exactly the same.
That is a highly accurate comparison, and this is where the Commonwealth aspect becomes a fascinating analytical tool.
How so?
Because these nations all started with the exact same base operating system, English common law. They share the same foundational precedents from hundreds of years ago.
Right, they all share those old UK cases.
But as they gained independence and their societies diverged, their courts began applying those shared principles differently, based on local economic needs and cultural values.
So if we extrapolate what an analysis focused specifically on a Commonwealth context implies, it really means comparing and contrasting how these related but now completely distinct legal systems handle the exact same business wrongs.
Yes. It is like observing an incredible, centuries-long natural experiment in market regulation.
A natural experiment. Give us an example of how that plays out.
Let's look at how this plays out in practice with a concept we touched on earlier: pure economic loss.
Okay.
This is when a business suffers financial damage without any physical property damage or personal injury.
Like the logistics truck knocking out the power grid. My factory didn't get hit directly, no machines were physically crushed, but I lost $1 million in downtime because the power went out.
Precisely. Now, historically, the English courts were terrified of allowing claims for pure economic loss because they feared the floodgates of liability we talked about. They generally held that unless there was physical damage or a very specific, special relationship between the parties, you simply couldn't recover purely financial losses in tort.
They wanted to keep commercial liability strictly confined to contracts.
Exactly. Keep the Wild West contained.
That's the other Commonwealth nations.
As you move across the Commonwealth, the analysis really splinters. The Supreme Court of Canada, analyzing the exact same foundational precedents as the UK, eventually took a slightly different path.
They branched out.
They did. They developed a more flexible test for establishing a duty of care, sometimes allowing recovery for pure economic loss in situations where an English court would absolutely deny it.
Interesting. What about Australia?
The High Court of Australia took yet another nuanced approach. They started focusing heavily on whether the plaintiff was vulnerable and unable to protect themselves through a contract.
So an analysis of tort in business Commonwealth isn't just looking at one monolithic set of rules. It's tracing the diverging branches of a family tree.
That's the perfect way to phrase it.
You are looking at how a Canadian judge defines commercial vulnerability versus how an Australian judge defines it, all while both of them are referencing the exact same historical UK cases.
And this cross-pollination is totally unique to the Commonwealth.
They look at each other's work.
All the time. A judge in New Zealand dealing with a totally novel business tort, let's say, a complex dispute involving algorithmic trading and automated market manipulation, they can look at a recent decision from the UK Supreme Court or the Supreme Court of Canada for guidance.
But are they forced to follow it?
No, the Canadian decision is not legally binding in New Zealand. The New Zealand judge can completely ignore it if they want, but it is highly persuasive.
Because they speak the exact same legal language. They use the same analytical frameworks for duty, breach, causation, and damages.
Exactly. They are participating in a global, ongoing dialogue about the rules of commerce. So a Commonwealth business tort law analysis is a deeply comparative exercise.
It's tracking the evolution of market regulations across this geographically dispersed but fundamentally connected network of legal minds.
Right.
This makes the inclusion of the word Commonwealth so much more than just a geographic boundary. It is an entirely different method of problem solving.
It really is.
If a business wrongs another business, the way a Commonwealth court figures out how to make it right is totally dependent on this rich, overlapping history. It's practically a living, breathing history project.
And for a modern multinational business, understanding this specific analytical method is absolutely vital.
Yeah, I'd imagine so, because
When
you're
it-
crossing those borders all the time.
Right. If you are a software company based in Toronto and you are expanding your operations into Sydney and London, you are operating entirely within the Commonwealth framework.
So you have to know how the rules slightly shift.
Understanding how tort law shifts slightly from one jurisdiction to the other, how the duty of care regarding data protection might be interpreted slightly more strictly in London than in Sydney, based on recent precedents, that can be the difference between a minor operational hurdle and a devastating company-ending lawsuit.
You really can't just rely on your contracts being airtight in one country and assume you are safe everywhere else. You have to understand the specific flavor of the Wild West in each jurisdiction.
You have to know how the local sheriffs interpret the law. And in the Commonwealth, the sheriffs are constantly reading each other's notes.
We've covered massive ground, starting from just a handful of words. We took Commonwealth business tort law analysis, tort in business Commonwealth, and unpacked an entire framework for how commerce survives.
It's a lot packed into a short phrase.
It really is. We started with the broad idea of analyzing legal frameworks, examining the friction and the gray areas between the rules. We explored how contracts are just private universes, while torts act as the immune system of the broader market, handling the unexpected collateral damage of aggressive capitalism.
And we walk through the deep mechanical analysis required to actually prove a civil wrong.
Right, establishing the duty, proving the breach, tracing the complex web of causation, and calculating the financial damages of a stolen secret or a ruined reputation.
Finally, we looked at the specific jurisdictional lens through which this text views all of this. The shared legal DNA of the Commonwealth, the power of precedent, and the comparative analysis of how different nations adapt the same historical principles to modern economic realities.
Understanding this intersection helps you grasp the invisible guardrails that dictate how businesses are allowed to interact with the world, with consumers, and with each other.
The law isn't a static thing that simply happens to a business. It is a constantly evolving set of parameters. I mean, it is the ultimate social contract layered over every single private business agreement.
It really makes you look at the market completely differently. Every storefront you see, every targeted advertisement, every corporate acquisition, you can see the potential energy of all those unwritten duties of care and the historical precedents holding them in place.
It's everywhere once you know what to look for.
We've talked extensively about how business torts are the unwritten rules of commercial interaction and how the Commonwealth system relies on history and geography to enforce those rules. But I want to leave you with a final thought to mull over, one that stretches beyond this historical analysis we've done today.
Looking to the future.
Right. How much do you think those ancient precedent-heavy rules will have to evolve as businesses increasingly operate in digital, entirely borderless spaces?
That is the million-dollar question right now.
Consider a scenario for a moment. What if an artificial intelligence company, incorporated in one jurisdiction, scrapes the proprietary data of a business in another jurisdiction using a decentralized network of servers located in a third?
It happens every day.
We are suddenly far removed from the physical boundaries of traditional commonwealths. When the economic injury happens in the cloud, spread across multiple legal traditions simultaneously, how does a system built on local precedent and geographic history adapt?
It's going to be fascinating to watch them try.
Where exactly is the court, and which sheriff's notes do they read? Keep an eye out for those off-the-ball fouls. Until next time.